Thank you, Mr. Felton.
My lord, you set us a few tasks.
Yes, I
during
did.
The lunch of Germany.
You're on your toes.
On the rather large question of what's the government's approach to contract of employment?
Yes.
What I am instructed to say is the matter was described as a very large question by the Supreme Court in the O'Brien and Ministry of Justice case, 2013 ICR 499, and one which the Supreme Court concluded they need not and should not decide. There is no fixed position on the matter. We have accepted for the purposes of this case that there's a contract of employment, and I would urge your lordships not to make this the case in which you...
No, don't worry. There's no suggestion we were going to do that at all. But I just wanted to know whether it was still an open question.
It's still an open question, and a very large question, according to the Supreme Court. My lord, I believe that you have had handed up to you two authorities that you asked for, the Prudential case, and I say you, the collective you, and then also the Morris and Bailey case. We have also looked at the two cases.
Just on the prudential assurance, what does it say on the point that we were looking at? Which is the passage that... It was about the word purport, wasn't it?
It's paragraph 28, I think, deals with the specific point. Page 954.
Oh, yes.
I see. Well, thank you. That's require some further thinking about.
Then, my lord, I think a copy of Klein and Weir.
And I must, Mr. Feeney, it would be once bitten, twice shy. We got this in the All Englands because it is not in the law reports. Is that right?
I'm not sure that. I can't answer that.
Can you check?
We will check. I think we can see what is said in Chitty, because if the Chitty footnote only refers to the All Englands, then...
Well, that's pretty, yeah. I mean, there are some cases which aren't, but it's worth just checking. Yep, okay, thank you.
And my lord, I think the Tyne and Weir case we're getting...
I didn't ask, I just wanted you to look at it.
So we have looked at it. We don't see that it adds anything to...
No, that's fine. I'm
analysis.
not offended, but I just...
But the other matter, the Neely case, that has sent us on a helpful journey to the...
yes, it was only as a route map, yeah.
Mrs. Justice Slade's decision in Potter and Northumbria Acute Hospitals Trust. A copy of that is coming over shortly, and there is discussion in there around this point of variation, and I'll come to it.
Fine. Okay, good. Well, I just didn't want it to be overlooked. Up to you what you make of it.
No, thank you very much. So, my lords, going back to my submissions on the law, I started to introduce the Aberhall case.
Yes.
And I talked about the difference between a variation or a change which has immediate practical effect and one which is not immediate. The case which picks this up and which Aberhall was describing is referring to, one of the cases is Jones and Associated Tunnelling case, which is an EAT decision that Mr. Justice Brown Wilkinson was presiding. And you'll find that at page 35 in your authorities bundle. And the case essentially concerns a change to a contract which is to do with the place of work. The place of work. And the relevant passage is at paragraph 22 of the judgment, which you find at page 39. And this is where it is stated, to imply an agreement to vary or to raise an estoppel against the employee on the grounds that he has not objected to a false record by the employers of the terms actually agreed is a course which should be adopted with great caution. If the variation relates to a matter which has immediate practical application, e.g. the rate of pay, and the employee continues to work without objection after effect has been given to the variation, e.g. his pay packet has been reduced. That's, my lord, where I was referring to the distinction between protesting in advance and protesting thereafter. Then obviously he may...
It is e.g.
E.g.
Yes.
Well, e.g. his pay packet has been reduced. But it's the previous sentence.
Yeah.
Continues to work after effect has been given. Then obviously he may well be taken to have impliedly agreed. But whereas in the present case the variation has no immediate practical effect, the position is not the same. It's the view of both members of this tribunal with experience in industrial relations with which the chairman, without such experience, agrees that it's asking too much of the ordinary employee to require him either to object to an erroneous statement of his terms of employment having no immediate practical impact on him, or to be taken to have a sense of the variation. So to hold would involve an unrealistic view of the inclination and ability of the ordinary employee to read and fully understand such statements. So where there is an immediate application and there is no protest and you continue to work, then you may well be taken to have impliedly agreed. That's what that case is suggesting.
Yes, interesting word suggesting. I just tried to look at the facts quickly. This is just an obterdictive view, is it?
It's an obterdictive view.
It's just a comment generally, rather than a binding decision.
It is an obterdictive view which then receives the imprimatur, I suggest, of Lord Justice Underhill and the court in Appellant.
Okay.
Then we pick up the case of Selectron, which is at page 66 in the bundle, which is another decision of the Employment Appeal Tribunal, this time presided over by Mr. Justice Elias. And the case concerns enhanced redundancy payments. And there is a passage at paragraph 30, page 69. The fundamental question is this: is the employee's conduct by continuing to work only referable to his having accepted the new terms imposed by the employer? That may sometimes be the case. For example, if an employer varies the contractual terms by, for example, changing the wage or perhaps altering job duties, and the employees go along with that without protest, then in those circumstances it may be possible to infer that they have, by their conduct after a period of time, accepted the change in terms and conditions. If they reject the change, they must either refuse to implement it or make it plain that by acceding to it, they are doing so without prejudice to their contractual rights. But sometimes the alleged variation does not require any response from the employee at all. In such a case, if the employee does nothing, his conduct is entirely consistent with the original contract continuing. It is only referable to his having accepted the new terms. Accordingly, he cannot be taken to have accepted the variation by conduct. So where, for instance, there's a change to redundancy payments, which won't kick in for several years, then carrying on work would not be referable to an acceptance of those terms. And again, this principle is endorsed by Lord Justice Underhill in Appellant and both cases at paragraph 85. If I can take you to Appellant again, we pick it up at page 185 in the bundle. Where his lordship says, and this is not highlighted, to take the position that to continue to work following a contractual pay cut.
Can I just check what the facts are? My lord will remember it, but it's, taking a paragraph out of context.
I explained. I
This
thought
is where
I'd explained the facts already.
their pay was cut, was it?
No, they didn't receive the pay progression that they...
Well, but it was effectively a pay cut because contractually they were entitled to a pay increase each year, so-called pay progression.
And they hadn't received the pay increase.
There was a pay freeze.
For 2 years.
Okay, right, thanks.
Sorry, thought I'd explained that earlier.
Yeah, okay, so entitled to, but did not receive.
To take the position that to continue to work from a contractual pay cut could never constitute acceptance would be contrary to the dicta of both Brown, Wilkinson, J and Jones and Mr. Justice Elias in Selection in an area where the specialist expertise of the EAT must be accorded particular respect, and I do not believe that it would be right in principle. A contractual offer can, of course, be accepted by conduct, and that must include the offer of a variation. Under a contract of employment, the parties, and this is material, I say, for this case. Under a contract of employment, the parties are in a complex relationship in which they are both required to perform their mutual obligations on a continuous basis, and these obligations are frequently modified by their conduct towards each other. I can see no reason why an employee's conduct and continue to perform the contract in circumstances where the employer has made clear that he wishes to modify it may not, in principle, be reasonably understood as indicating acceptance of the change. As for Choudhury, is another case in this kind of field, the general language of paragraph 46 of Justice Jacob's judgment must be read in the context of his overall reasoning. He did not rely on the simple proposition that silence can never indicate consent. Rather, he went on to give particular reasons why it was not proper in the circumstances of that case to infer the employee's acceptance of new terms which the employers sought to impose, namely that those terms had not yet bitten, and also that the employers had expressly sought the employee's acceptance in writing, but he had not given it.
Well, then, balance, you need to read the best para.
My lord. Oh, I'm going to go on.
Yes. Sorry.
I'm going to go on. So, what Lord Justice Underhill then goes to say is it really depends on the circumstances of the case. Neither Jones or Selection went further than saying that continuous work following a contractual pickup might constitute acceptance. The language used was may well be taken to have agreed, and it may be possible to infer. And then Lord Justice Underhill seeks to identify points which have come out of the cases. First and foremost, and that's 87 to 89, the inference must arise unequivocally. If the conduct of the employee in continuing to work is reasonably capable of a different explanation, it cannot be treated as constituting acceptance of the new terms. That's why in Selection, Mr. Justice Elias used the phrase only referable to. This is simply an application of ordinary principles of the law of contract and also of waiver estoppel. It is not right to infer that the employee has agreed to a significant diminution in his or her rights unless their conduct viewed objectively clearly evinces an intention to do so. To put it another way, the employee should have the benefit of any reasonable doubt. Secondly, protest or objection at the collective level may be sufficient to negative any inference that by continuing to work, individual employees are accepting reduction in their contractual entitlement to pay, even if they themselves say nothing. This is clear from Rigby and Ferodo, which is the only House of Lords authority in this field. And then thirdly, as Justice Elias used in paragraph 30 of the phrase after a period of time raises a point of some difficulty. It is easy to see how it may not, depending on the circumstance of a particular case, be right to infer acceptance of the contractual contract. As from the day that it is first implemented, the employee may be simply taking time to think. As Justice Elias' formulation is intended to recognise that a time may come when that ceases to be a reasonable explanation. However, it may be difficult to identify precisely when that point has been reached on anything other than a fairly arbitrary basis. In Choudhury, Lord Justice Jacob discomfited counsel for the employers when making that very point. But again, that passage needs to be read in the context of the fact that in that case the variation is not yet bitten, and I do not think the difficulty in identifying the precise moment at which an employee should be treated as first accepting contractual pay cut means that the question has to be answered once for all at the point of implementation.
So it's got to be unequivocal and it's a question of fact.
My lord?
It's got to be unequivocal and it's a question of fact.
Yes, but it's an objective, looking at it objectively.
Can I just ask you the question that Lord Justice Jacob in Choudhury discomforted Mr. Craig with, which is, if you want to find it, it's paragraph 80, paragraph 47 of the extract.
Yes.
When was the offer of variation accepted? Was it the day after the offer, when the claimant came into and was allowed to work, turning that into this case? Was it the day after the check-off was first withdrawn, or when? Yes, well, that's really the question.
My lord, I thought you might ask that question.
Oh, good. Well, then you will have an answer prepared.
And there are, which is a very fair question. My lord, I'm going to put forward several possible dates or times. Firstly, it was when the first time at which check-off wasn't applied.
What date was that? Was that before or after the collective grievance point? What was the date?
Oh, it would be after the collective grievance point. But basically, if check-off was withdrawn, let's say the 1st of December, so that was the last pay run, then it would be the next pay run when
the next payday.
the next payday. That would be the first time. Second time would be when the individuals themselves converted to direct debit.
How could that be an acceptance?
Because in the context of knowing that check-off is not being provided, it is...
The contractual acceptance has to be communicated to the other party.
So your client would never know that they'd taken out a direct debit on a Thursday afternoon?
Well, they may not know the precise date upon which that...
They won't have known at all. How will they know?
Well, they may well know if these people continue to be members of the trade union.
How will they know that?
Because the individual claimants are trade union officials, so they would know.
Oh, well, that's an oddity about their particular cases.
Well, these are the claimants in this case.
In all of the cases.
In all
three cases.
I believe in all of these cases.
Not just the Cox ones.
I think in all of these cases.
Right, I hadn't realised that all of them
had. I believe so. If I'm wrong on that on the facts.
Some are, I know, but I hadn't realised it was all. But in any event, it can't turn on that, can it?
My lord, if there are some who are not, they will be.
So where's the unequivocal communication in a trade union official going off on a Thursday afternoon and taking out a direct debit?
No, it's the fact that they've continued to be a trade union official.
No, but I'm sorry, that's not your second point. Was when they converted to direct debit,
and it would be known to the employer that they've continued to be a trade union member because they're a trade union.
Well, they wouldn't know that necessarily. Suppose they go and do the direct debit.
That's my second proposition.
But you wouldn't know. They wouldn't know whether or not that was because they'd taken out a direct debit, or they were waiting to strike in this very court. They wouldn't know. Your clients might be thinking,
well,
they're
they
coming
would
in
know that they
for
weren't
us.
striking this court because they've not been sent a letter before claim for 5.5 years.
Well, then, but for 5.5 years, if they don't know.
So, but anyway, so my first proposition is the first pay date. The second proposition I've said is the taking out the
direct debit.
The third date will be the second pay date.
Would be the second.
The second time that that check-off has not been applied, because looking at the language of Mr. Justice Elias, employees may need a reasonable time to think. So it may not be the immediate first payroll date, but then it's the second one. And then one can repeat each and every time there will be a further date from which it can be inferred that there has been acceptance.
What? Because of silence and not making a protest?
Because of silence, not making a protest, in circumstances where the employer has informed you that this is what they are ceasing to do.
Okay, but you're relying on silence.
And
simply, I mean,
in the context of the mutual trust and confidence, which applies to an employment relationship, which I'll come on and
so it's silence and absence of protest and possibly direct debit. That they...
and fundamentally, but I'll come on and discuss that shortly because you just asked me the date. It's the mutual trust and confidence.
Mutual trust and confidence, yeah.
Where then there comes a time that then I would say after the Kavanagh judgment has come out and the lack of any communication from individual employees or from the trade union, because at that point in time it should reasonably be known to these individual claimants, because they've all said, we were aware of the Kavanagh case, that they could, to assert their rights, if they wanted check-off to be reinstated, because they thought it was an important contractual entitlement.
Just remember, I know that remedies, the damages were put off. Did the individuals in Kavanagh get a declaration at least? Was there any remedy? So they got a remedy on 1st of May 2016?
Well, they got there was a declaration. On liability, yeah, declaration.
There was a declaration on liability.
They didn't seek any remedy other.
No, exactly. That's why I was leaving aside the unions. So the individuals had got a remedy on the 1st of May, when it was 3rd of May.
The individuals knew, or should be taken to have known, on the 15th of May 2016, that employees on their own case, they were regarding it as a test case. I appreciate that it's not a formal test case, employees in somewhat similar circumstances have been found by a court to be entitled to continue with Chekhov, and they said nothing and did nothing thereafter. So yes, it is inaction and silence, but it's in the context of them continuing to work.
Yeah, what you really have to say is, in Underhill, I said, obviously there, in principle, one thinks how can inaction and silence ever be consent? But I went on to say, in the context of an employment relationship, it may be.
Yes.
Because of the continuing relationship.
And there's a further explication.
But questions of expectation obviously come into it. You could say, well, you really would expect that if they were continuing to preserve their position, we would have heard after the end of Cabinet.
Yes. And my Lord, I'll just take you on this point, because it is a fundamental part of our case. Paragraph 110 in Appellant, which is in the judgment of Lord Justice Elias, Sir Patrick Elias, and that is agreed with by Lord Justice Ryder. At page 187, it may be said that the employee should never be held to have accepted a variation simply by working without protest under the new terms without more. After all, a party can bring a claim for breach of contract within the limitation period without having to notify the other party that he objects to the breach, and why should this be different? I think the answer lies in the fact that the employment relationship is typically a continuing relationship based on good faith, and exceptionally, in that context, it might be appropriate to infer that a failure to complain about a proposed variation of the contract for the future may be taken as agreement to that variation which prevents it constituting a breach. It might also be said that an employer can always put the position beyond doubt by lawfully terminating on notice and introducing the varied contract, which includes the new disadvantageous term or terms. No doubt the employer's reluctance to do that is in part motivated by desire to avoid potential unfair dismissal claims, but there are also less selfish reasons. In the context of a continuing relationship based on good faith, dismissing and re-employing might appear to be an unnecessarily hostile stance, only to be adopted as a last resort. Attempts to secure agreement should not be discouraged, and exceptionally the just circumstances may justify the inference that the employer has agreed to the new terms, even where he's been reluctant to do so formally. So again, we're dealing with the context of an employment contract.
Yeah, it's the same point as I think as I made.
It's the same point that you've made, but it's
put better.
My Lord, it's put different.
I may be the only person who doesn't, the court who doesn't understand this, but at the moment I don't understand the link between a continuing relationship based on good faith and inferring that a failure to complain is an unequivocal representation.
Because in a context, in a relationship of continuing good faith, if one is harbouring an intention to sue your employer or is protesting in one's mind about a change that's been made, that would offend the trust and confidence that the employer would have.
That's the least attractive way of putting it. Isn't it better simply to say that in such a relationship, you would reasonably expect someone who is continuing to protest against something that has been done, effectively to do something about it, or at least to say, I'm reserving my rights.
You might, but if there isn't, just to make sure clear, because I think others understand this better than I do. If there's no duty as such, I still don't understand how the fact that you're in a complex relationship, if there's no obligation to say, I'm thinking of suing you, I don't understand where this unequivocal statement comes
but my Lord, the obligation does arise from that duty. You don't, under the Limitation Act, you don't have to sue until 6 years, but under the duty of trust and confidence, for your employer to retain the trust and confidence in you as an employee, you ought to, therefore you're reasonably expected that you would at least tell the employer that I disagree and I reserve my rights under protest at the change that you have made to me, which has an immediate effect.
Why, in circumstances where, at least to an outsider, it seems obvious that the reaction might be adverse to the employee who tells them that, either sidelining them or treating them differently?
In the absence of any evidence of any kind of retaliation for these for employees.
Well, there isn't any evidence of retaliation because they didn't indicate. But
no, but
these
are these are circumstances, my lord, where there is no evidence that an employee would not speak out because of fear of consequences.
I think we'd have to say, wouldn't we, that the doctrine, if you can call it that sort of pompous phrase, the approach which both I and Sir Patrick take, goes beyond the conventional proposition which you would find in Chitty, that silence can never be consent unless you can show a positive duty to speak out which has not been complied with. That was certainly very live because Mr. Seidel put his case that high. And you can see it in paragraph 83 of my judgment. And he refers to a passage in Chitty saying precisely that.
Yes.
And effectively what Sir Patrick and I were saying was, in this context,
yes,
the law isn't quite as strict as that.
Exactly. And
you don't have to say a duty in the sense of a contractual duty. Yes. Might be right, might be wrong, but it's certainly, I think, both of our ratios.
Yes, it's only the ratio. I'll put forward the proposition of Lord Steyne in the Daly case that in the law context is everything. Here we're in the context of an employment contract, which is well regarded by all parties to that contract to include this trust and confidence term.
Okay. We're not dealing with fiduciaries, are we?
We're not dealing with fiduciaries.
You cited yes, passages in your skeleton.
And I'm not going.
You're not going.
I'm not going. I'm not going.
Thank you.
We're not dealing with fiduciaries. But my lord, when one looks at the Chitty on waiver by estoppel, they say specifically, mere inactivity will not normally suffice, which means there will be circumstances in which inactivity, and these are exactly those circumstances.
Well, my Lord's point is this, not coming from an employment law background, from an ordinary contractual background, everyone accepts normally, but the abnormal situations are the situations where there is a positive duty to speak.
Yes.
The difference here might be said that in this context, a positive duty to speak is replaced by something a little bit toned down, which is an expectation that you will speak given the nature of the relationship.
Yes. So my lord, I certainly accept, coming from a strict contractual place, one would perhaps look askance at what's being put forward. What's being suggested is this is not to apply to every contract, however it is drafted and in whichever context, but it's peculiar to the employment.
But it's not really breach of any contractual duty of trust or confidence. All you're saying is you're trying to work out what people are doing, and in a situation where they're turning up every day for work, the employer is providing work and paying them, and things have changed. If people don't say anything, there may be circumstances where that indicates they are content to the extent of having a vary. That's all you're saying.
That is what I'm saying. And if I put it higher than that, then you'll knock it down or temper it in a judgment. But the principle is well accepted by all the judges in the Underhill case as a principle. And of course, it's a question of fact for the particular circumstances of the case. We say here a fortiori because of the amount of time that the employees sat on, in a sense, sat on their rights if they had those rights.
Can I just ask one final question? Just so that I begin to get the feel in the same way as my lords obviously have the feel in the concept of employment law. You say about the expectation that the employee would say something because they're going on being employed. But what does that actually mean in the context of employment? What would the employer do differently if, for example, a year earlier, these claimants had said, "We're thinking of suing you"? What's the difference?
Well, there may be difference. It may be the employer would say, well, if they're going to sue us because we can't we can't remove Chekhov, we might have to terminate the contracts of employment. That's
a very good reason why someone wouldn't want to
and re-engage. Or we may have to negotiate something anew, and we might have to offer something in return for that. So there are lots of things that the employer might wish to do in response. And here, what we see is that the employer continued to facilitate the ability of the trade union to move employees from what was the check-off scheme to the subscription.
You say we see that here. You've referred to it before. I haven't actually seen.
I will show you some evidence
okay.
on that. I mean, they sent out communications. They had warnings on email messages. They provided facilities time for this to be done.
Well, look, show it to us properly, or not at all.
No, my Lord, I'm going to show you. that. I'm just trying to.
You're just trying to respond to my
question.
Intervention.
There are a whole variety of things that they did actively, and then there are things that they might have thought about doing in a sense defensively.
I think,
but I don't think we need to go that far, my Lord, because it is, I would submit, axiomatic within the employment contract that one needs to be clear as an employee, certainly over a period of time, that one doesn't accept a change.
Yeah.
And if one doesn't do so, one will readily.
I understood my Lord to be asking largely about the formal position, to which the answer I think is the one given by Sir Patrick Elias, which is that if you want to introduce a change and the employee doesn't accept, makes it clear they're not accepting the change, what is formally open to you, and employers, if it's important enough to them, do it, is you do what you'll fire and rehire. And that's what Sir Patrick refers to in the second half of paragraph 110. You say, in fact, it happened on the facts of Aberhall at a different point. We are dismissing you from this contract because it doesn't suit us anymore, but we're offering you re-engagement on an identical contract, but without this term, without checkoff. And it's not terribly popular at the moment, but it's been well recognised to be a term in an employer's armoury, though one that neither side likes to take. They don't like to take it.
The nuclear option. But what Sir Patrick Elias went on to say, though, is there are less selfish reasons why the employer doesn't do that.
Well, don't worry about whether it's selfish or not.
No,
Formally, that's...
in the context of a continuing relationship based on good faith, dismissing and re-employing might appear to be an unnecessary hostile stance, only to be adopted as a
Well, I see all that, but that's just mood music. The legal answer is that if the employer wants to put it to the test, they obviously can't change the contract unilaterally because that's a contract. Yeah. But you can sack them and rehire them, and they then have to decide whether to accept rehiring on the new terms, or if they don't, to claim for unfair dismissal.
That's right, and so that's why we're in a different context to perhaps other situations. Now, on the facts of Aberhall, the argument, I believe, by Mr. Laddie was that this was a perverse finding, and reading the judgment very carefully, it looks as though the court had some sympathy with that submission, albeit they didn't accept it finally.
Well, you're entitled to draw attention to the fact that both Sir Patrick and I expressed our conclusion in terms of saying that it was a conclusion the judge was entitled to reach.
And my Lord, that is certainly the way it is worded. And 101, my Lord, in your judgment, that is a powerful submission, and I've not found this part of the appeal entirely easy, which I think is another way of us reading the runes on this. Now, on the fact, in support of your conclusion, my Lord, in that case, you relied on a number of factors which are then looked at by the courts below, and I just want to take you through that, because obviously each case will turn on its own facts, but in that case, you relied on 3 factors. The proposed variation was wholly disadvantageous to the employees, not part of the package of favourable and unfavourable. That obviously is a relevant factor, but it doesn't mean that you can't seek to impose an unfavourable term only, and for that not to be accepted. Then, my Lord, you said the matter was not put to the employees as something which their agreement was required. There was equivocality on both sides. Now, My lord, if you were seeking there to set out a general principle about equivocality, then I would take issue with that as a matter of law. It's important, though, to look at how the employer has conducted themselves in the particular case. So, for instance, if you have, as in Choudhury, where the employer sends a letter to the employee and says, do you accept these terms? And then the employee doesn't respond, then from that, one can see, well, the employer hasn't pushed things, and therefore their position is equivocal. But you don't have to send a letter. You don't have to require the employees to say yes or no, I do accept it, because there is this general inference that you can draw over time that they have accepted it. And here, the employer has already made clear its position by saying, we are taking away Chekhov. They don't then need to go on and say to the employees, please sign here that you accept. And if you don't do that, then that's regarded as a factor against you when one is looking at objectively what has happened. But the third factor that my lord relied on was the fact that there was strenuous protest on the part of the unions, not only up to, but beyond the date of the implementation of the pay freeze. That's at paragraph 104, my lord. Now, my submission is that where there is only a protest before a change, the change is implemented, and then there is silence, no reserving of rights, no continuation of a collective grievance. That is a factor which points to an acceptance of the change.
This comes back to the question I asked before. You keep asserting repeatedly that the non-continuation of the grievance process was an act on the part of the individual, and I just don't know that.
My lord, I'm going to take you to that.
Right,
at this stage, my lord, I am.
Okay.
I know where I need to go to answer that point, my lord. I'm just seeking to establish the points of principle.
And is the point the degree of protest? It has to be strenuous, or is it just it must continue beyond the date of implementation, or is it both?
At a minimum, it has to extend beyond the date of implementation. I would suggest there needs to be strenuous protest.
So at least the more intense, repeated and insistent the protest, the harder it becomes to ensure unequivocal acceptance.
Exactly. But where there's nothing at all, it's easy to draw.
So don't be polite. Go and bang the door every Monday morning.
Or what needed to be said here by the individual employees was, we're carrying on work under protest. Each time that you take away, you don't give us Chekhov, we regard that as a breach of contract.
I don't think any degree of strenuousness would have been necessary if they had written a clear, very polite letter saying we're going on working without protest, under protest.
Yes. But those are all factors that need to be taken. And just to confirm the point around the mutual trust and confidence, because I know my Lord Justice Stuart-Smith has some, not so concerns about that, but
I'm working on
must understand a little bit more about it. In Crane, Mr. Justice Choudhury, if I can find my reference to it, at paragraph 53, which I think you have in page 59 of the Crane bundle. In the middle of that paragraph, he says, an employee who is in a continuing relationship based on mutual trust and confidence cannot ordinarily expect to continue working for lengthy periods approaching the limitation period for a contractual claim without being taken to have accepted a contractual variation. Now, obviously, in that context, he says there's been a protest and ongoing litigation. But he, and my Lord, to the extent that you were not aware, Mr. Justice Choudhury was himself president of the Employment Appeal Tribunal. So we have the views on this point of three presidents of the former presence of the employment tribunal.
Yeah, well, I'm suitably intimidated, but I may not have given up just yet.
No, but one doesn't need to be intimidated. One needs to just understand that in this
Just
context,
explain where I am.
in this
Thank you very
in this context, there is a difference from what you may instinctively feel from other areas of law.
So that's why I'm asking.
So, my lord, if I can now, and then just to pick up on the issue of waiver, I mean, my primary submission is that if there is a variation, then it would follow that there is a waiver of the previous breach. There is no point in this.
Well, hang on. No, that's what's confusing two things. If there's a variation, there's no breach.
If there's a variation, there is no breach.
The waiver doesn't come into it.
Well, no. If there may have been a breach for a period of time until there's a variation, which is why you asked me.
They may have a couple of years.
Yes, but okay, but then that wouldn't. Well, are you saying that if there'd been a variation at the end of year one, that would also constitute a waiver of the breaches of the previous breaches? I don't.
Yes, well, personally, it's a waiver. It's a waiver of breaches going forward.
Oh, it's not a waiver of
No.
breaches going forward.
It's a variation.
Your variation going forward, you need your waiver for going back.
But it is my submission is that it logically follows that if you're not protesting, you're accepting the breach, you're not suing for the past breach.
No, that
that
doesn't
you are
follow.
waiving the
Because variation is when the terms of the contract now no longer include the obligation to provide a facility. That's one thing, and we know there will come a time, and it may be hard to fix. The separate question is, what about breaches that have happened before? The fact that you have agreed a new set of terms for the future doesn't mean you've got to take everything on the chin that's happened before. You can still be sued for that. You did the wrong. Somebody can sue within the Limitation Act.
My lord, in the context here again of the employment contract, where we've talked about being honest with your employer, or an expectation of honesty, if you are again here silent about the past breach and silent about the past breach and inactive about the past breach for a period of years, that must amount to a waiver.
Well, I don't know. You haven't really told us what you mean by it. What are the relevant principles about waiver?
So a waiver is an unequivocal representation that you will
acted on by the representee to their detriment.
Acted upon by the employer. It doesn't have to be to their detriment.
You haven't acted on it. You've done it anyway. You've cut them off at the knees a year ago.
No, but you haven't taken any steps in terms of the prior breach. And so
I thought you had to. I thought the employer had to rely on the non-action. What have you done in reliance on the non-action? You cut them off at the knees when you took away Chekhov the year before.
They have done that, and then they have taken steps to facilitate the changes and moving over to.
Well, what's that got to do with waiver?
Because it's part and parcel of the same of the same arrangement.
I see. They act on it. Part of the rest of it has to be to their detriment. Believing that there is no opposition to the withdrawal of Chekhov,
yes.
They have spent resources, probably not money, but resources, helping the employees substitute a direct debit arrangement.
Yes.
I see.
That just sounds as if you're saying if you negligently run somebody over in a car and say, shall I drive you to hospital? And the chap says, oh, God, that would be very helpful. He's then waived his breach to damages. I mean, it's your breach. If you try to persuade him not to sue by taking steps to remedy things, that's one thing. But to say that he's given up any contractual right that he has does seem a very strong thing to say, doesn't it? I understand variation when both parties say, right, we're going ahead on this basis now.
Well, my lord, it's the same. My submission is the same principle. The ongoing relationship between the employer and the employee is on the assumption that there were no extant disputes between you. Because if there is a dispute between you and your employee, you would expect them to
no, because they could say, right, I accept it now. I carry on working from Monday the 1st of January 2022. but I'm not going to give up the money I should have had from the 1st of January 2020.
I appreciate if we're
and
dealing...
if that's the case,
but
then the union could at least bring the damages claim for the period up to variation.
We're dealing with the individual employees here. Not the union. This is about the individual employees, not talking about the union at all. If there was a pay claim, I absolutely accept the proposition that you're not, merely because you're varying for the future does not mean that you're waiving for the past. Yep. But we're not dealing with a matter which involves any losses to which the individual employees.
But there will have been a contract and there's been a breach, and that is two things. One, they can at least get a declaration that there has been a breach. And secondly, if there was a contract for the period up until waiver, it does mean, because of the Third Party Contracts Act, that you do then have the question of, for the period up to variation and change of the terms, how does the Third Party Contracts right work? Anyway, I hear you.
My proposition, my lord, is that you are, where there's no monetary loss, there is no purpose in you suing for a declaration that there has been, or suing that there has been a breach for that period of time where you receive nothing. Okay. You as an individual don't. And therefore your silence and inactivity must be taken to be a waiver of the breach. That's consistent with the ongoing relationship between the employer and the employee.
Okay. Can I just be clear how variation fits in? I obviously hadn't understood how you were putting it. I had thought that variation was an alternative on your case to acceptance. Waiver was an alternative to variation. Rather oddly, I'm sure there were good reasons for it, Mr. Laddie. In Aberhall, Mr. Laddie went out of his way to say he wasn't running a case on waiver; he was only running it on a variation. So I can understand that. There are, in a sense, two ways of putting the same case, but there might be subtle differences which made it better to put it one way than the other. But the way you've developed it so far is as a backstop to cover the situation where you win on variation but not from day one. And therefore you're concerned about the intervening year or 2 years and want to say that if you win on variation at the end of year one, you can then you must also win on waiver for the intervening period.
Well, my lord, if I can explain
yes, do, that'd be helpful.
Why this matters is because of the impact of Section 2 and Section 3 of the 1999 Act. Because
so are you saying it wouldn't matter but for that?
Wouldn't matter at all but for that.
Whether you called it variation or waiver?
If we were only looking, if this was only a claim brought by individual employees, it wouldn't matter whether it was a variation or a waiver because they've suffered no loss in this particular case.
But the problem that I've got is you do have a trade union, and if the contract exists in particular terms and provides for a facility being offered, and if that contract is not varied and the facility doesn't have to be offered only after a particular date, whether or not somebody chooses to bring a claim for a declaration, that does mean the union for that period can bring a damages claim.
Well, the union can bring a damages claim or can seek to bring a damages claim, whatever the individuals do.
So if the four individuals have waived the breach in this case, but if say the breach occurred for 2 years after Kavanagh or something, and they waived the breach for 2 years, so even if they went to get a declaration, they'd be told, no, you waived the breach. Are you saying that the employer could still sue for those 4 employees' loss of subscriptions for the 2 years?
Let me look at it the other way. Show you how this fits. So I think we need to look at Section 2 and Section 3.
Okay.
So you find those, my lord, at page 12. Sorry, well, it's page 12 and page 13 in the authorities bundle. We look at page 3, page 14 first, section 3. It says subsections 2 and 5, 2 to 5 apply where, in reliance on section 1, which is what we've already looked at, proceedings for the enforcement of a term of contract brought by a third party. 2. the promissor shall have available to him by way of defence or set off any matter that, and then B, would have been available to him by defence or set off if the proceedings had been brought by the promisee. So if the promisee brings a claim and the defence to that claim is waiver, then that means that the third party cannot bring their Section 1 claim. And my learned friend and the PCS has accepted that waiver, if the individual employee is waived, then that falls within Section 3. To the extent that it means that they can't bring a claim.
Well, no, to the extent that they waive.
To the extent that they waive. To the extent that they waive. So if the individual employees here have waived their breach at any period, with respect to any of the period, but let's say for the entire period, then it means that that knocks out the entire Section 1 claim for the PCS.
And that's because waiver by estoppel, although at first sight you could think of it in terms of variation going forward from the moment of agreement,
Yes.
and waiver covering the breach that's gone back. In fact, waiver by estoppel can cover the period going forward as well, because the estoppel may operate to prevent someone asserting the opposite going forward.
Yes.
And probably a reasonable notice clause somewhere in there, but
Yes.
but so they, in terms of time, they can overlap.
They can overlap.
And I think your submission was that if you get an unequivocal agreement to the terms sufficient to found a variation, I think you probably need to hedge it a bit by saying that is almost certainly on the facts.
Yes. That would be a waiver going forward.
No, it's
And
different.
backwards.
It's different,
Yep.
but it would support. It may well support a waiver by estoppel, both going forwards and going back.
Well, that is my that was what I was seeking to argue.
That's what I thought.
However incoherently, but that is the point that I was making.
Still pretty coherent.
That's why waiver matters, because if we go back to Section 2, so yes, Section 2, my lord, on the previous page, it's a bit more complicated, because it says, subject to the provisions of this section, where a third party has a right under Section 1 to enforce the term of the contract, the party to the contract may not, by agreement, rescind the contract or vary it in such a way as to extinguish or alter his entitlement under that right without his consent if A, B or C applies. So obviously this is designed to deal with what I said earlier about the broker or something where the parties to the charter party say, well, look, we'll vary it and kick out the rights that the broker might otherwise have had. That can only be done with his consent. If it's without his consent, certain factors have to apply. So you can't just extinguish someone's rights.
I accept that, but the charter party case is talking about what in other circumstances would be called accrued rights, once the rights there. And so in this case, it seems to me that it's absolutely critical that you just work out what you're talking about. It goes back to what my lord raised with you first thing this morning, because if the right to be enforced is simply a facility, which I think was the way it was put this morning, one can see how changing that may be said to affect the rights of the union. But if you frame it in slightly differently, which is that if and to the extent that an employee requests check-off, which they are not obliged to do, then if and only to that extent the union has a right, then there's no question of changing or challenging or rescinding, because that continues on. The only effect is that people don't request check-off.
So, under the terms of the contract, as decided by the court, which we can't appeal from, they have decided that the individual employee continues to have a right to ask for check-off and to have it applied to them.
So the answer you gave this morning, because this is why I asked you this question, the benefit is the facility, not the receipt of a specific amount of deductions where they've been authorised.
No, it's asking for the facility.
It's the facility.
It's asking for the
Yes,
facility.
because that involves them going and getting a form,
Yep.
taking it back to the employer then having to make the deductions and hand them over until the authorisation is withdrawn.
Yes.
And it's that facility which is the benefit that you concede, because I haven't seen anything describing the benefit, but that is what the benefit is, you say.
The benefit is that if I'm an employee and I want my payment to the trade union.
No, the benefit isn't for the employee. The benefit here is for the third party. That's what I'm asking about.
If I'm so just going back to basics, the employee would like for his or her membership dues to be taken out of their payroll and handed over to the trade union.
Yeah. That's the term that he or she has got.
That's the term that they've got.
But the benefit under
And the
Section
benefits
1,
of that is if the authorisation to do that has been provided by the employee, because they have to give authorisation under the statute. You can't have any, as my lord will know, under what was called the Wages Act, you can't have any deduction made from your wages without express authorisation. So if the authorisation has been provided and the employer says, I'm not going to do it, then they've been deprived of the right.
no, we are completely cross purposes here. There are two people in this marriage, not three. One is the employee and one is the trade union. The employee is a contractual right. And what I asked you this morning was what was the benefit for the for the trade union? And I'd understood you to say that the benefit for the trade union, which is the one that's in section 1.2b, I think, or whatever it is, was the benefit of having a facility whereby the employee could ask for authorise and ask for deductions to be made, they would be made and handed over. That it wasn't, so far as the benefit for the union is concerned, the payment of particular amounts of money.
Yes. It's not the benefit of the payment of a particular sum of money.
It's the facility.
It is the facility.
Right, okay.
And I think I said that.
That's what you said this morning.
And
And that's what I thought you said.
And I maintain that because it's not as if the employer is holding the money
No, exactly.
on behalf of
and the union might want to go and
not paying it
persuade
over.
people to join and say to them, look, there'll be this facility available.
It's simply providing the facility.
Yeah.
Yeah.
But
And
coming
strictly
back-
speaking, I don't think this matters. It's not a facility made available to the union. The benefit to the union is that a facility is made available to the employees.
Yeah, which has the effect of
Exactly.
when it is implemented.
When somebody decides to avail themselves of the facility, money will flow into the union coffers.
But dealing with section 2, and this is in a sense why I'm making the submission as I am on variation and waiver, section 2 requires, in a sense, the consent of the third party if there's to be a variation, unless A, B, and C, or one of those is not satisfied. A waiver provides a complete defence. One doesn't even need to get into any of that.
Hang on 1 second.
But what happens if we find there's no waiver then?
Well, then,
Aren't you then
you
into
need
section
your
3?
formulation of the benefit rather than what I was putting to you
Yes.
to get into your argument about not being able to change it.
Then one is in the situation of what is the benefit. The benefit is, well, there's a facility, and you've taken away the facility, but you've not taken away any money that the union
Doesn't
is
matter
entitled
because
to.
the benefit is the facility.
It's quite odd, isn't it, to enforce the term of the contract. What's the term of the contract?
So the term of the contract is if I authorise my employer to make a deduction at source and transfer over to the
It will be done.
it will be done. And and just to explain that, we do have the wages.
The term of the contract, yes. I think the facilities, the term of the contract is there will be that facility,
There will be that facility.
operated.
Yes.
The employer will put in place machinery, and he's done that by saying you get the form from the organisation, you send it off to the payroll, and it'll be deducted the next pay thing. And if you stop, it'll stop from the time after. It's not just the payment, it's a mechanism, which is why I've called it a facility, whereby should you choose to do so, payments will be deducted and handed on.
And my lord, just to explain why this is important, it's the first page in the authorities bundle is what was then known as the Wages Act 1986, which actually goes back to the Truck Act, I think, of early 1900s.
I've heard of it. I might even have
Truck
thought
Act
I
goes
read
back-
it
And even earlier than that, I think
Truck Act goes
the
back to
1870s.
1832.
1832. So, but the position is that an employer shall not make any deduction from any wages of any worker employed unless his deduction is satisfied by the following conditions. It is required or authorised to be made by virtue of any statutory provision or any relevant provision of the worker's contract, or the worker has previously signified in writing his agreement or consent to the making of it. And
So you
that-
lose on waiver. Now, say we find there's a 2-year period. This is hypothetical.
Yes.
But there's a 2-year period where we think there hadn't been agreement to a new contract, and that didn't happen until 2022. And there was a 2-year period when the contractual entitlement on the part of the employee to have a facility available, and the benefit for the union was to have that facility available. So there's been no waiver for that 2-year period. And Section 3 doesn't help you then to avoid remedies for that period, does it?
So what I would have to then fall back on is whether or not we can fall within Section 2,
Yeah.
and that the variation was by consent. And there I would argue that the trade union has given its consent to the variation. It may not have given express
Sorry, just
consent.
before we get to that, it's quite important, but just so that we don't make a mistake in our judgment, why have we put the Wages Act in? The Wages Act has not been enforced at any relevant time.
No, it's just, it was explaining, below, we were dealing with, is this actually a contractual entitlement or not? And we were actually saying, no, it's actually just giving effect to the terms of the Wages Act. But it's relevant to...
No,
But on this appeal...
no, it's may reflect to the terms of Part 2 of the Employment Rights Act 1996.
Yes, that's where it is now. It was there because we were dealing with historical,
I see.
a historical position.
Yes, I see.
And
Okay.
but
Sorry,
it-
now
it-
coming back to the more
You've got
important
a
point.
2-year past historical period when the employee had a right and the union had a benefit consisting of a facility. And
Yes.
what happens for that 2-year period?
Right, if I can just...
Yeah.
So, my lord, if the variation is after
The
let's say, a
variation,
period
we
of 2
think,
years,
is, let's use variation to, so we know what the terms are. Variation covers a period going forward.
Yes.
The contract terms have been changed, so there is no longer an entitlement or
Yep.
corresponding benefit to a facility. So all we're looking at is the past period, and we've used waiver to describe that, and sadly we're assuming you've lost. So what happens next then? You've got no defence for that
I've got
2-year
no,
period.
I've got no defence for that.
Yeah. Because there's no consent for the past period, is there?
There's no consent for past period. The consent will be for the variation.
So there's
The
no
question
defence under
then
Section 2
becomes-
if you lose on waiver under Section 3.
Yeah. So then the question becomes when, if there is a variation,
At what date?
at what date?
Yeah.
But
And
even if
next, if so, does it go backwards?
Well, and if so, is there consent? Because the employees themselves may have varied the contract by saying, we're quite happy not to have check-off anymore. But unless there's the consent of the union, that doesn't affect their claim for damages going forward.
So if you can't get a backwards variation, a backwards waiver, you've got no defence. And going forward, you're saying you need 2 things, are you?
Variation
Needing-
and consent.
Yeah.
Yeah.
And how have you got consent?
Well, here we say the consent comes from the trade union through its inaction, impliedly accepting the position that the employees have taken.
It's effectively relying on the same facts.
It's the same fact. It's the same fact because the employees have varied. The trade union, as in a sense in this case, is the mouthpiece or acting as the agent of the employees through the protests and the lawsuits and so forth, is taken to go along with, coincide with what the employees.
And how is it communicated disassent?
Again,
By silence.
my lord, through silence, through not
There's
saying
no
anything.
mutual trust and confidence. Trade unions don't have to ring them up and say, you know we've fallen out, don't you? There's no obligation
Well,
there.
they don't have to, but they have to. But have they consented to the employees' mutual trust and confidence? Because that's what this is about. Not whether they agree to themselves; it's whether they've consented to the variation. And if the variation is on the back of trust and confidence,
Well, what? Sorry, I'm being slow. My lord, I think, has got to the bottom of this, but I just haven't followed it. why for the future have you got to proceed on the variation route? Isn't tactically, from your point of view, no matter whether it works, why don't you put all your eggs in the basket of variation? Never rely on acceptance as such.
Because variation, my lord, doesn't extinguish the right of the
Third party
to enforce the term unless they have consented to.
No, I know, but if you establish waiver,
if I've established waiver, then I'm then
quits in.
yes, exactly,
then I'm
quits in
quitting.
forever.
Which
So
is-
why
which is
would
my
you ever
primary-
why would you ever bother with acceptance?
Because he wants to have two strings to his bow.
Because, my lords, you might not accept.
But I
waiver.
can't see any circumstances in which you would win on acceptance but not also win on waiver.
That is possible, but
Well-
I'm seeking to argue
Well,
that.
I'm not. I'm not trying to give you points you're not taking for yourself, but I'm just trying to understand how it all fits. If you can establish that the employees didn't speak up in circumstances where their failure to speak up would be where they would be expected to speak up,
Yep.
that would establish a waiver subject only to you acting on it. I suppose that is that the point.
That is a point.
Yes,
One
I
of-
see.
one-
So for
one-
waiver, you've got for waiver, you have got the extra element of
There's an extra element.
of acting in reliance. Okay, I'm there.
So my primary submission is that there was a waiver of any breach on the basis of the inaction, the silence, which amounts to an unequivocal representation in the circumstances, and the employer has acted on it sufficiently to make it inequitable for the employee to sue for the breach.
Yeah.
If I'm right on that, then that knocks out all of the 1999 Act claim on the
Yeah.
part of the PCS. If I'm not right on that, but you find that there was a variation, that then begs the question as to, is that a variation with consent? And if so, it will only apply to the future, therefore the period after the variation, but it doesn't protect me for the period
Yeah.
before that. And my submission on variation with consent is that the trade union must be taken to have behaved in the same way as the employees. They wouldn't act inconsistently with its members. It's giving respect to them complying with the duty of trust and confidence.
Although it's very odd because the duty of trust, I mean, anyway, we've had that argument. It just seems strange.
Well, because we are looking at, do they consent to their variation? Do they consent to the way in which they've behaved, to the way in which they have conducted themselves, which is to accept the variation? So,
Okay. Well, I think we are spending a lot of time on this point. It is difficult and important, but I think we've probably got.
I think you've got that point, my lord. I then need to just go through quickly
Yes.
what we say are the areas of law.
Yeah.
Well, and then
On-
at some
and then
point
this is where I need to
we're
pick
still.
up.
Lord Justice Lewis is panting to be shown the material about grievance, and I'm panting to be shown the material about I've forgotten what now. Can't be panting that much. But there was some factual.
Your point, my lord, is about the new contracts entering into
No. It was about My point is about
reliance.
the reliance. You were going to show
Oh,
us.
yeah, I'll show you absolutely, and I'll show you.
Okay, you're going to do that, but not just yet.
No, I'm going to do it all now.
Okay,
And-
good.
And I'm going to do it, my lord, through looking at the skeleton arguments,
Yep.
and essentially I rely on the skeleton arguments in respect of all three of the cases, and I'll just take you through that as quickly as I possibly can. If we take Cox first, in the core bundle, from para 17, on page 42. This is our skeleton argument for the full hearing. And to the extent that I don't get through any of this because of time, then I do ask you to read the rest of it.
Which para did you say?
So we're starting at paragraph 17, my lords. It's essentially, the judge wrongly applied Appellant to the agreed set of facts. Do you have that? Very bottom of
No.
page 41 in Cox.
41. So I always said 42.
Yeah, sorry, 41. Then we move over to 42.
Yep.
So, Firstly, it's a point about the way in which the judge compared Appellant, where we say he equated the muted protest at a collective level, in this case, to the strenuous opposition by the trade unions in Appellant, which included holding a ballot of industrial action. The second point, and this is hopefully going to answer...
Unfortunately, it doesn't, but go on.
No, but because I need to show you why.
Yeah.
The judge found that the PCS had not withdrawn its opposition to the change despite its failure to proceed with its collective grievance by following the defendant's grievance policy. We need to look at, but if we look at the judgment in that case, at 101, this is the finding of the judge at paragraph 29. Where it says, check of arrangements, my lord, you have that, page 101.
I've got it, yeah.
Check of arrangements in the Defendant Department ceased as from 1st of December, and on 5th of December, they lodged a collective grievance. The grievance does not appear to have been progressed by the defendant because of her insistence, in line with her collective grievance process, that the grievance be brought on her behalf.
But I don't know whether that insistence is justified or not. I just don't know.
It's not a point that's being disagreed with by my learned friend, and I'll show you where it's made good in the evidence.
Okay.
If that assists.
That's the problem that I've got.
No, I understand, but my lord, that is the finding of the judge, that it was in line with the defendant's process.
Because
and
of
my lord,
her
that was
assistance in line with her collective grievance process.
yeah, and her meaning the HR for the Home Office. So my lord, in the supplemental bundle, and we haven't gone to that, we have a witness statement of Mr. Parr. Which begins at page 192, supplemental, and I just want to take you to 210. And it's
210.
210, my lord, and it's paragraphs 53 to 54.
Shall we read those to ourselves?
Yes, please. Mr. Parr is asserting that that is the proper approach.
Okay.
Then in reply evidence, Mr. Jones, who is for the witness for the PCS, at page 188 in that bundle, at paragraph 48, doesn't say that that is wrong.
So where's the
For
reply?
page 188, it's paragraph 48. This is Mr. Jones.
Okay, one second. Right. One.
Ah, my lord, I'm actually taking to an even better document, but at 142.
Okay.
And this will answer my Lord Justice Lewis's point, I hope. Bottom of 142 is actually the quote from the collective grievance process.
Oh, that might be helpful, yes. Oh, that's, yes. Thank you.
So, my Lord, I'm sorry, I've only just been reminded of that paragraph.
Okay.
And at 48, Mr. Jones...
48, what page?
This is page 188. Mr. Jones doesn't disagree with the that is their policy.
What he says is they didn't believe you would deal with it seriously even if they got two people.
Yeah.
But it was page 142 I had.
But it's 142, and my Lord, I'm sorry it's taking so long to get there.
Yeah.
So, my Lord, yes, there is a grievance that is issued, but it's explained to the trade union, not that you can't proceed with the grievance, but you need to do it in a way that is our process. And the union doesn't go through the proper process. And that, we say, is the kind of silence or inaction, but it's really on the back of some action to signify that they are not continuing to protest. And the employer is entitled to proceed on the basis that the protest has been withdrawn. And then we hear nothing for over 5 years. Then we say,
Hang on 1 second.
no, my lord, I'm just reading from the skeleton argument.
Yep.
The judge was wrong to rely on there being equivocality on both sides. My lord, this is picking up a point that I made earlier about equivocality and whether or not it's a general principle from Appellant. The defendant was clear that it did not regard check-off as a contractual right at the point of removal. It would have been inconsistent with her position to tell her civil servants that continuing to work would be deemed to be a contractual variation. So the fact that they haven't said so can't mean that they were being political. Where one of the contractual parties does not regard the provision being removed or altered as contractual, the onus must be on the other party to make clear its objection. They failed to do this, and the defendant was entitled to assume the issue was resolved. Then the next point, the judge viewed the act of setting up direct debits as a step of mitigation in isolation. The proper context, we say when applying principles on the construction, including variation of the contract, is to look at the act in context. The relevant context was that the individual claimants were continuing to work without protest at an individual level at least for 5 years. Then
You can't add anything, can you? Either their conduct is such that it doesn't amount to an unequivocal representation, or whichever we're talking about, in which case going off and doing a direct debit is obviously consistent with mitigation. If, on the other hand, their behaviour is such, communicated behaviour is such, that it represents agreement, unequivocal agreement, then you can then see the direct debits in a different light, but it doesn't add anything.
I think it's how you, it's whether you, it's which light you see it in. Yes, the
It
judge here.
It doesn't add anything one way or the other.
Well, my lord, given the discussion we've had earlier about communication, I appreciate how difficult that is for me to advance.
Okay.
But yes, in light of the fact that there's silence, that is a further factor. Then we say the judge erred in saying the substantial gap of time did not alter the analysis. It plainly does, and I explain that point there. Then there's a reference to the other litigation, and I've really made all those points.
If they got a declaration in Cabinet, the individual employees would know that the remedy they were seeking was available in Cabinet. I can't see any reference to Cabinet, but overnight somebody will double check that an order was made by Mrs. Justice Elizabeth Lane granting a declaration.
Well, even if she didn't grant the declaration, it's clear at the end of her judgment that that's what she is saying. Okay? So she's saying that they have a contractual entitlement to the facility.
Right.
Then, my lord, in Crane, my skeleton argument is at page 28 of the Crane Court Bundle. The relevant passage. And it's paragraph 45, 8d. The judge found that the PCS had lodged collective opposition, not a grievance, on behalf of the individual claimants, and this has not been withdrawn.
So sorry, whereabouts are we in?
I'm at the top of page 29, my lord. It's paragraph 45 of the skeleton argument.
Thank you, yeah.
So this is not a case of a grievance being issued or a letter before claim being issued. It's just prior to the implementation of the removal, there was opposition from the PCS. And we say the finding wasn't reasonably open to the judge. Both parties proceeded, we say, on the mutual understanding that certain staff had a contractual right to check off, because within the DEFRA category of employees, there were some who had the same term which had been highlighted in Hickey, because they'd come from a different department. And it was them who was being referred to as having contractual rights. And check-off was not removed for them. Check-off was moved for those who didn't have that in their terms and conditions. So the opposition from the PCS on behalf of the remainder could only be construed as a matter of industrial relations, not representation of contractual intent. There were no
What does
collective...
that mean?
Because in their earlier letters, the PCS had said some people have contractual rights.
No, I understand that bit, but what's the distinction being made between being construed as a matter of industrial relations, not as a matter of contractual?
Because they're basically saying we don't like what you've done. So it's equivalent of going back to the collective agreement point. We don't like the fact that you're reneging on a collective agreement. That's an industrial relations matter. If the term hasn't crossed the bridge into the individual
Really,
contract.
your point is collective.
Point is collective. But there were no collective or individual grievances raised at all in this case. And then we've got the piece, and then we've got Kavanagh, again, no communication whatsoever. And then again, there's references to the judge was wrong about equivocality on both sides, which is the point I've already made. Then, my lord, there's a point at paragraph 50 which deals with new terms and conditions that the individual claimants signed up to. So after Chekhov had been removed, individual claimants entered into new contracts of employment. And we say that those new contracts of employment did not include Chekhov because Chekhov had already been withdrawn. And the guidance, or the code, only gave the right to Chekhov when it was being offered by the employer. It was no longer being offered by the employer. And so the entitlement no longer existed. Sorry? That's paragraph 50.
And that only applies to this department, though.
Well, it applies to all departments where, and in all circumstances where individuals enter into new contracts of employment after Chekhov has been
Yeah,
withdrawn.
but it was only this department. You haven't told us in Crane, the Home Office, or Smith HMSC.
Well, perhaps, is this a different way of putting it?
Yeah, because there was
People
a-
are accepting new contracts
there
all
was
the time
only-
in all departments. You mean these individual,
it was this
in this
individual
proceeding?
claimant. Yeah, there was only one claimant here. It was in Smith where that was relevant.
Well, not in Smith, but we're in
In
Crane.
Crane.
Sorry, in Crane.
But there,
Sorry, all in Crane did it. All in Crane and one in Smith.
Right. So
So
it
that's
doesn't
relevant.
affect Cox.
It doesn't. We'll have to look at that. No, it would have. Yes, in Cox there would have been two contracts.
the point wasn't taken in Cox, was it?
This point wasn't taken there, but it's the same principle.
No, okay.
I just don't understand the facts now. I don't know whether or not. I thought this paragraph 50 was that they all signed up to new contract terms, and I haven't heard anything like that in Cox. And are you telling me that in Cox, the four individuals, like everybody else in the Home Office, all signed new
No,
contracts?
in Cox we're going to come to talk about two individuals.
Well, we've got the two, one who moved from Waterloo
Yeah.
to Croydon, and the other woman who was temporarily promoted in Peterborough.
Yeah. So in those,
Okay,
for
so
those,
those two
for those
factors.
two,
Okay.
the new contracts must be taken to not include
Right, yeah.
Chekhov. So, my lord, I'm going to have to take that back on Cox. It's only in Crane that we. It may be. I'll get instructions.
But what are you taking back?
What I've just said is that in Cox there were two individuals.
Yes, I see, okay.
Yep. I need to.
Well, we'll just say,
confirm that.
but you're not taking back the point wasn't taken in Cox. The only question is whether it could have been.
It's only a question whether it could have been.
Yes, okay.
So we've got two people who were promoted in Crane at the moment, that there were new contracts that we know
So
about.
that's Cox. I'm apologising if I'm.
Sorry, this is what I've written down. In Crane, all the employees,
All the
which is
employees
three,
entered
all
into
three
new
employees.
contracts.
Yeah.
And in Smith there was one who entered into a new contract. The reason why this.
I'm sorry. Okay, I'm sorry. I'm not up with the facts.
Well, my lord, I've tried not to get into all those.
Well, they may be important to.
They are.
He erroneously found the new terms and conditions that the individual claimants signed up to following promotions. Now, it's probably in the judgment somewhere. Does that mean they signed a bit of paper saying, I have new terms and conditions? Which don't, did it say in terms that they don't include?
No, they don't say in terms, but they are.
Can we see what they signed up to? Is it in the supplementary bundle?
But what they will have signed up to is incorporates all the other documents from where the check-off term comes. But the check-off term in the code says where the department offers it, this is what will happen. At that point in time, it wasn't being offered.
Yes, yeah, okay, I've got it.
By the employer.
Yeah, okay.
And my lord, in Smith, if we go to the core bundle, I think it's at page 31. Sorry, 81. Paragraph 31.
This for Mr. Siegel, I think. Does it make any difference that they weren't offering it because they were actually in breach of contract?
Sorry, my lord, I didn't hear.
Does it make any difference that they weren't offering it because they were acting in breach of contract and breach of collective agreement?
Well, in breach of contract, yes, not in
But
breach
not
of
breach of
collective agreement. Yeah, yes, is the answer, it does.
Thank you.
Which paragraph in the Smith skeleton am I looking at?
My lord, it's paragraph 31.
Well, hang on, sorry, but they were. The premise of the argument is that these were new contracts.
They were new contracts insofar as the section 10 point is concerned. They were not new contracts in the sense that all of the terms of the old contracts were agreed not to apply.
Yes, I think we better wait till
Okay.
Yeah,
I mean, I'm getting a bit confused, but
if I can just put it this way, because I'm sure this will be uncontroversial, the way in which within the civil service and for all of these claimants in all three cases were promoted or given new terms was, as one might expect, by way of a letter or statement which said, the following is new, I paraphrase obviously, the rest of your terms remain as they were. So no one ever got a piece of paper saying, here is in its entirety a new contract.
yeah. Okay.
And our point is that when they get the new terms, check-off has already been removed for that particular term.
I'm sorry, which issue are we on at the moment?
No, this was just explaining this point in the skeleton argument.
Yes, but I'm not even sure which point the skeleton argument is on. Perhaps it's because it's mid-afternoon. But, I thought we were still on facts relevant to waiver and estoppel, to waiver and variation.
Yes.
We're not on the point which we're coming to later about the effect of having
we're not onto that, but obviously there's a crossover because that might include a new contract.
Okay. So why is this relevant to waiver and estoppel?
Because you're entering into a new contract where it's a variation. You're entering into a new contract where check-off doesn't apply. Therefore, you must be taking.
I think it's the language you're using. I just think of variations. There's a document, this, and I change it. I think of a new contract as a new piece of paper, this, to do it visually.
Yes.
And I thought you were saying when there was a promotion, when there was a state of affairs where somebody was promoted, in the legal universe, this goes there and a new one comes up. And because the new one that comes up at a time when there wasn't a reference to check-off, this new piece of paper, which is not a variation, it's a new contract, was the thing that applied. But have I misunderstood?
Well, no, I think the reason why I'm carefully using the word variation in that context is because we're going to come on to talk about, is that a new contract, which is the final point of our submission. So it is a variation of.
Well, there's a changed state of affairs, which
affairs.
may translate into the legal universe as an alteration of a pre-existing contract,
Yep.
or the termination of that pre-existing contract and the creation of a new contract.
And however one describes it, at the time in which they enter into the new arrangements, when the new state of affairs applies, Chekhov has already been
Gone,
removed.
yes.
Therefore, they must be taken to be accepted that Chekhov has removed in respect of themselves, whether we call that a variation or a new contract.
Hang on 1 second.
And then, my lord, on
I see, okay.
on Smith, skeleton argument, which deals with the criticism of the findings below, is page 81, page 31, so paragraph 31 through to '44.
So which pages?
So page 81 to 84, paragraph 31 to 44, and this includes, my lord, the issue of the letter before claim that was sent in 2015. And that's set out at paragraph 33. The letter before claim was sent on the 15th of April. It threatened an urgent application for interim declaratory relief if the notice given to remove Chekhov was not rescinded. And then there was a reply sent by the government legal department. This letter, and that was before the court, this letter repudiated the proposed claim, confirmed, however, that GLD was instructed to accept service. There was no response from the PCS's solicitors. No claim was served and no further legal action was threatened until
I'm really
5.5 years later.
I'm on the wrong page. We're in Smith.
We're in Smith on
your
page
skeleton.
81, my lord. Page 81, paragraph 33.
Yeah, in the last few lines of 33.
Thank you so much. Sorry.
So, even though there was a letter claim,
Yeah.
it wasn't acted on. And that feeds into all the arguments I've made about inaction, silence, acquiescence, etc. Right. Then in terms of my Lord Justice Underhill's question about the steps that were taken by the different employers in terms of facilitating the move, this is referred to in in the Cox case in the Mr. Parr's statement at paragraphs 45 to 50, page 208 to 209.
So,
So, my lord, page
Which pages?
208 to 209 in the supplemental bundle for Cox. Paragraphs 45 to 50 are a whole series of steps taken by the Home Office to facilitate the move from Chekhov to direct debit, and and Chekhov was removed on the 1st of December 2014. So many of these steps were taken after Chekhov was removed, and therefore we say they support the argument of reliance. Letters were sent to members, there was communications on the Home Office intranet provision. They authorised floor walks by PCS representatives. They hosted a stall in the canteen. They gave access to the internal telephone directory. They put a news story on the staff intranet. Paragraph 48, all of these occurred after Chekhov had been removed.
okay.
In DEFRA, the Crane case, We see Mr. Robbie's witness statement at 215. Paragraph 42.
Well, it's a bit meaningless to a human being. Use the facility time to speak to members. What's that, Mr. Tone?
Individual trade union officials were given time off to do trade union activities. What they arranged for them was they could use that time to basically work with, talk to members of the union who work for DEFRA to talk about moving from one thing to another.
Is it more or less the same as paragraph 49(1) in the last statement we looked at?
It would be
With those floor walks and
it's equivalent.
Sorry, I've got lost. Which paragraph?
We're looking at 42, my lord, paragraph 42. Use of facility time to speak to members. There is an obligation to provide facility time, but that facility time doesn't also mean that the trade union officials can go through, talk to members who are otherwise working.
No, exactly. So the benefit or the reliance was saying to people, you don't have to work for the next half an hour.
You can talk to access to members at work, including surgeries and workplace meetings. Use of the departmental email system to send information to members. So it's not just using their own lines of communication. Use of DEFRA IT to access the PCS website so members could sign up to direct debit. And it goes on to say, after this, the PCS interactions, the topic with DEFRA focus on measures to encourage employers to set up direct debit subscription payments, which we facilitated as explained above. So those were reliance measures by DEFRA. And then with respect to Smith, we have in Mr. Keen's witness statement on page 52 to 54 in the supplementary bundle for Smith. Which is page 52 to 54, paragraphs 52 to 57.
Which paragraphs?
I've got written down 52.
No, which just give me the numbers, please.
52 to 57, my lord. And then just telling you the timings. Smith, Chekhov was removed 56. And you see at paragraph 56, those measures continued beyond the removal of Chekhov. They agreed to extend the support measures until the end of October 2015.
Okay.
So, my lord, we say that that is evidence of reliance insofar as that is necessary to establish waiver, which is obviously my primary submission in terms of this change in the existing state of affairs for the purposes of the 1999 Act. But if it's not waiver, it is further evidence of objective evidence as to whether or not there was a variation.
And do you also say that the involvement of PCS goes to the question of their consent?
Well, that would go to the question of consent, as in they, in a sense, much of that they asked the employer to help them with this. And
I mean, what they're not saying is, this is outrageous, we shouldn't be having to do anything with direct debits.
on these cases, yes.
We should have Chekhov.
Yes. With these three cases, in these three cases, yes, because it's not going alongside issuing legal proceedings.
You say these three cases. What
So I'm talking about these.
qualification
I'm talking about not. This is not a Hickey situation. It's not a Kavanagh situation where legal proceedings have already been issued.
Yes, I see.
This is a situation where the trade union has remained silent as to how it's dealing with these matters. In particular,
But then engages in acts to do with the implementation of the new system, you say, basically. That's your point, really, isn't
yes.
it?
And we say that if there is a variation, it's a variation with consent. Because, in a sense, they are affecting the change in light of the removal. So, my lord, the final point. My lord, just in time, we have the Potter case to hand up copies of it. It is in the IRLR because I think it is only.
I don't mind it being in the IRLR if it's not also in the
It is
ICR.
only in the IRLR, as far as
In that
we are
case,
aware.
that's entirely justified.
And required by the practice direction. Says track record to the left. Yeah.
Thank you.
So the final ground of appeal relates to whether or not individuals entered into contracts after the coming into force of the 1999 Act.
Is this just for Davy and Speakman, or is it for others?
Yes. It is with respect to those two individual claimants, but my lord, you will appreciate that there are probably thousands of other claimants behind this.
But
Because
in these cases, it's only two claims.
it's only these two claimants.
But your point is that if we lay down principles on this,
That will be of great assistance to the parties when coming to look at the issue of damages, if at all. Because under
Possibly
the...
if anyone was taking sensible steps to settle the other 7 cases.
My lord,
Or possibly if anyone was taking sensible steps to settle the other 7 cases.
my lord, my lord, obviously, whatever is decided here is going to have an impact on those other cases. The simple proposition is if you were an employee pre-1999 Act and you didn't enter into a new contract, the PCS cannot enforce on it because the 1999 Act has no purchase. So the question is, what is entering into a contract? Because the language of the statute is entering into a contract. And my lord, the skeleton argument addresses this at paragraphs 55 to 57 in Cox. So pages 55 to 57 in Cox, not paragraphs. Paragraphs 52 to 61. So as we say there, it's common ground that the PCS can only claim damages under the 1999 Act in respect of those members who entered into a contract after 11th of May 2000. The language of the statute is a contract entered into. There is, as our researchers have ascertained, only one case dealing with the 1999 Act which is thought about this point, and that is the case of Mulcrone, which is quoted in the Cox judgment.
that's Gavin Keeley, QC.
Yes, my lord. And we say the only point of principle taken from that judgment is that a minor variation to an existing contract does not amount to entering into a fresh contract. But the deputy judge did not make findings on when a variation is so fundamental it becomes a new contract.
And anyway, his approach isn't binding on us. We could take a completely different
Oh,
approach.
absolutely. So the question here then is, what does entering into a contract mean in the context of an employment situation, and in particular, an employment situation like this, as my learned friend Mr. Siegel has said. Employees don't get a document which says, here is your new contract of employment, whenever any changes are made. So one has to ask the question from the surrounding circumstances as to whether or not where some variation, some change in affairs has happened, is that entering into a new contract? Now, my lord, the Potter case that we were helpfully guided towards by my learned friend, by my lord, not by my learned friend, in a sense is helpful, but also not necessarily conclusive on this particular point, because the ultimate question is, it depends. And
Yes, well, one thing on which it depends is for what purpose you're asking the question. There's no magical idea, this is a contract, that isn't. What did the drafters of the 1999 Act have in mind when they used the phrase entering into a contract?
Yes.
A difficult question to answer is I think they didn't really have employment contracts in mind at all. But that in itself might be relevant.
Yes.
Well, and Rod said they didn't have in mind at all, as we know they mentioned them in
Well, they know they
Section 6.
mentioned
But the whole thrust of it was it was typically a commercial contract, which probably typically would be short term or at least finite.
Yes.
Whereas here we have a relational contract which might last a lifetime, working lifetime.
A working lifetime. And my lord, so one interpretation which we would seek to urge on you is that entering into a new contract means entering into an entirely fresh new contract.
Well, that's
one
just adjectives.
Well,
I don't want to be picky, but it doesn't say entering into a new contract.
it says in relation to a
It says
contract
entering
entered into.
Exactly.
I mean, one view would be, and nobody's running this, and they're probably right not to be, one view would be entering into a contract means the moment when you sign up as a civil servant.
Yes.
And then from then on, there's always just one contract. And the fact that you may be promoted or moved between departments is a complication, of course. Let's just make it easy for ourselves and say you enter the Home Office, one department, and you stay there for 40 years. That's all a contract. That's all a single contract.
Yes.
Of course, the terms change, but then your pay will go up every year. So is that a new contract?
My lord,
Sorry, these are
no,
not
but
helpful
my lord,
observations.
I'm entirely content to take that as my starting point, which is that entering into a new contract is.
Well,
once
it's
you've
not
entered
what
into
you've
the
taken
civil
before,
service-
and I'm really just trying to thought experiment rather than to.
But my lord, it can't mean. I think we accept that on some level, where there is a fundamental variation to your contract, which would otherwise be regarded as a rescission of the old contract and entering into something new.
What, rescission? Let's not use that word.
No, it's another.
I'll try not to use that. It says,
I wonder if we should start with section 10, you see, because what's the purpose? What's the contract that they're talking about? The thing here is this act is going to allow people to enforce terms of contract for the first time when they're not parties to it.
yes.
So you're looking at the third party being able to sue under a contract. And I'm wondering, I don't know, whether it's looking at a contract which for the first time, if you like, included that benefit. It was there before 1999, before 2001, whatever the date was. And what they don't want is this act to apply to a term which is included in a contract where the contract which included that term occurred before the act. I haven't put that well, but can you see what I'm driving
I
at?
understand that point. So that the Act was not making retroactive the principle against privity of contract.
Yes.
They weren't making it retroactive.
So it only applies when, for the first time, a contract includes the term which is now said to be enforceable by the third party. That's what I thought on one of the many times I thought about this over the weekend.
Yes. Well, that is one interpretation of it, and
then I thought, how did that help?
well, so in this case, it would mean that every civil servant who was employed as at the 11th of May 2000 will have as part of their contract already, so this is just before the Act kicks in, they will have as part of their contract the entitlement to the facility of check. Because that's
So just to spell it out, if that is right, everyone who was in post on the 11th of May 2000, the union would not get any rights in regard to.
Exactly.
And they effectively, your exposure would run from May 2000 to the mid 2010s, depending exactly when each department did it.
Yes.
What happens when people shift departments? Because I know that you told us, I probably ought to know this, but you told us that there's delegation to,
Yes.
up to departments. When a civil servant moves from DEFRA to the Home Office, what happens then?
Fresh contract, but records.
They get a new contract of employment, or they get a new statement of terms and statement of
Identifying the employer as who?
The employer.
We're told,
the employer will,
theoretically, the employer is the Crown,
yes.
if it's an employer at all. But I bet you the contract talks about actually the Secretary of State.
It will refer to the particular department.
Refer to the
It will refer to the particular department. So we have in this case, I think in the Home Office, people who came in from the passport office, and then they came on to Home Office terms. So they will cut. So
I mean, that sounds, I'm just shooting from non-existent hip. That sounds quite fundamental to me.
yes,
But I don't know whether in employment law terms that would be regarded as fundamental.
Well, in all ordinary
Or a new
circumstances, a change of employer would be
We would-
jolly fundamental.
that is a new contract because it's between different parties.
Yes. The
question-
oddity here is the constitutional position that
But we're not, my lord. But we're not taking that point.
No.
So it has to be held against us that if there is a move from one department to another, and you're issued with terms with respect to the new department, that is a fresh set of arrangements.
That's accepted.
That is accepted.
Because I started this in a different way, you see. Rather than new and fresh and so on, in a very old-fashioned way, I picked up section 10 and I looked at it like this. It said, the Act comes into force on the day when it is passed, but does not apply in relation to a contract entered into before the end of that period. And then it says, the restrictions of which does not apply in relation to a contract which is entered into on or after the day which this Act is passed. So it's talking about an act of entering into a contract, by which it must mean the bringing about of relations, legal relations. And given that we're talking about enforcing the benefit, a term which gives the benefit to a third party, it must be that contract which had to have been entered into after the magic date, not before.
Yes.
So that's how I started. And then I started reading all the material from Mr. Davey and Miss Speakman to see how the documents fitted into that, rather than starting with the adjectives,
Yes.
which with very great respect, you use because you already have in your mind the result you want to get to. That's all right, but I was going back a bit further, trying to work it out, not being on either side at the moment.
Yes. Well, my lord, logically, the proposition that you're putting forward is
Correct.
Is correct and consistent with the language here.
So when Mr. Davey moved from Waterloo to Croydon,
That's not entering into a new.
well, that's what I wanted to
That's
see.
not entering into a contract. He's already entered into a contract. What then happens are variations to that contract. And according to the principles in Potter, for
we look at
different
Potter. I mean, we're sorry. This has been a helpful sort of chatting our way into the point, but we'd better let you make some submissions.
So the submissions are that the logic of the statute is that in anyone who was employed as at
Let me just
11th
write
of
this
May,
down.
anyone who was employed as at 11th of May 2000 and has not moved department where there would be a fresh contract entered into on any view, is excluded from the 99. The PCS is excluded from relying on that contract.
So, if you're in the same department, however huge your promotion,
Sorry, I rise because that's not before this court. I mean, I don't mind, in theory, if my learned friend wants to make an application to amend, but that is not before this court.
I had noticed.
Well, my lord, I will make an application to amend.
Having said that, Mr. Siegel, we'll have to think carefully about that, because I agree, I think in any view, if you want to say the point, he must amend so we can see exactly what the proposition is. But this is an important case which will have implications for other cases. So I don't think we will be wanting to be too strict as long as you are not disadvantaged. Anyway, let's see how we go.
Here we go.
You're not going to make an application to amend on the hoof, are you?
No, I'm not going to make it on the
Well, I think if you want to make one, you'll have to make it overnight, draft it overnight, send it to Mr. Siegel, and send it to us, and then we may or not we may consider it Dibeni essay, but we do need to know where we're.
My lord, we're not amending our case below. This is amending the grounds of appeal, or is seeking to.
Well, let's just look at Cox. What are the grounds? How are the grounds pleaded?
So, my lord, it's page 13 of that bundle.
This is why I asked you which ones is Davy and Speakman.
Yep.
And I know you want guidance, and part of the things that went wrong in this case is you're all rushing around seeking guidance from on high, but the first thing you need to do is establish the facts of the individual cases. And that's all you can do. And then if the next case is the same fact, or pretty nearly the same fact, it's likely the same result. But it's all a bit vague.
Well, yeah.
But
We might wish to be a bit more ambitious than that. I absolutely endorse what my lord said. We might want to, so far as possible, and being cautious when we only have a very limited set of facts in front of us, to identify a correct approach in principle, which would apply to more than just these particular facts.
So, my lord, what had been accepted below was that where there was a promotion, permanent promotion, that would amount to a fundamental variation of a contract, and therefore would fall within the ambit of the.
Yes, I see. So,
but I may wish to, and I'll take instructions overnight, wish to withdraw that concession for the purposes of making the argument on the back of the very logical set of questions from my learned friend, from my lord. Not my
all your
No
friends,
friend,
all your
yeah.
friends, we're all learned, but I don't.
My
We aren't your friends,
Lord
Mr.
Justice
Sheldon.
No,
Nor are we your enemies.
I appreciate that.
Hang on one second.
So for the purpose of these
So
submissions,
that, yes,
so for the purpose of my submissions, Debene essay, my first submission is anyone who is a civil servant as at the 11th of May 2000 and hasn't moved to another department has not entered into a new contract.
Or
A contract.
subject to withdrawing the
Yes.
concession
Subject to withdrawing the concession
about promotion.
about promotion.
So as we stand at the moment, it's promotion or moving department.
It's promotion or moving department.
Not entered into a contract to which the Act applies might be a better, more
Yes.
neutral way.
into a contract for the purpose of Section 10, perhaps.
Purpose of section 10. Beyond promotion, the proposition that we would put that to give meaning to section 10, other than the way in which my Lord Justice Lewis has put it, is that there has to be a fundamental variation to the existing terms and conditions.
Yes, well, that's all very well, and that might be what we're driven back to, but deeply unhelpful if there aren't. What is a fundamental variation?
So what we can say is and this is what we have sought to appeal, and that's what is in our skeleton argument, with respect to the two individuals that are dealt with in Cox, is that a temporary promotion and then a reversion to your original role.
Yeah, but
is
that's
not
that's a very specific
Well,
fact
that is a
situation.
specific-
What I'm really trying to think about, we want a workable result. Clearly, ultimately, it must be a question of what the statute means, but applying it into the context of civil service employment, I don't know promotion mean? I know that there are grades, but different departments have different grade structures. There's the fundamental distinction, used to be fundamental, though I believe it's breaking down, between executive grades and administrative grades. That maybe that's old-fashioned. I don't know whether that's still observed in most government departments. I suspect it is. But they're given different... What if someone moves from one to the other? That might be said to be fundamental. What if you simply move up a grade? You from being executive officer 1 to executive officer 2, or senior executive officer to junior. There will be dozens of different.
My lord, we accepted that was a promotion. If you've moved up a rank, that is a promotion.
Yeah, so that's the concession you may or may not be wanting to go.
That was the concession you made.
Back.
Any promotion from one grade to another, or from one.
So promotion was
set of grades
basically
to another.
moving from, and that is something you can always objectively see because every job has a grade.
Yes.
It wasn't so.
But for instance, changing the location from Waterloo to somewhere else.
The other problem, sorry to be so grim, and do throttle me if you like, but he didn't just change his location, you see. He changed the nature of his duties. He was checking passports, I assume, for the Eurostar at Waterloo. And then when he went to Croydon, he was doing detention. He was third country detention unit. It may be different duties and different skills and different perceptions. On top of that, and this is for Mr. Seeger really, although we are told there could be changes in pay, when I went through the underlying documentation for Mr. Davey, it was very difficult to tell, as a matter of fact, whether or not the changes were the result of the fact that he didn't have his inner London waiting allowance because he was moving to Croydon, or whether or not they were actually different pays. There was a letter with a different figure on, but that's because it came 10 years after he first started in the Home Office. So, although I know we want to get to principles, a few facts along the way are often helpful.
Yes.
The mere fact that one receives a pay increase would not, we say, amount to a...
But in practice, yeah, it depends what you mean by pay increase. Again, decreasingly so, but most government departments still have some kind of system of pay progression, however watered down.
Yes.
Sometimes it's said to be merit related, but everybody gets it, or performance related, but everybody gets it. If you get simply what the cost of living element in any year plus pay progression, because you have proved at least competent, that's a pay increase, or is it a pay increase? I don't know.
We've always conceded that was not
a
contract for the purpose of Section 10.
My lord, where you may get some assistance, or where I'd ask you to get some assistance, in the Potter case, at paragraph 72, although you may find that at the end of the day it doesn't get you very far. This is...
I can't remember why it mattered in Potter, but...
ultimately it's to do with an equal pay claim. But there's an analysis there of different ways in which different cases have been looked at, termination and so forth. At 72, it's not just a question of whether there's a fundamental change or not.
Yeah, well, we'll have to read this in context. I mean...
But essentially, my lord, if you have agreed to the mechanism of change, which is, for instance, a pay increase, that's already part of your terms and conditions, there will be pay increases in certain circumstances.
Well,
that's not entering into...
No, that clearly is, and I was really trying to...
But it's something outside of that, and I think we would accept that it's something where there is a fundamental change. Now, obviously, that begs the question of what is fundamental in different circumstances.
Well, yes, because I think when you talk about fundamental variation, I think what we're talking about must be a state of affairs is brought about, which is so different from the state of affairs that existed previously, that the correct legal label for the new state of affairs, or the changed state of affairs, is they have entered into a contract for the purpose of Section 10.
Yes.
Yes.
Yes. Well, my lord, I think that's...
But the key phrase there is for the purpose of Section 10.
Yeah, for the purpose of Section 10.
Because in a different statutory context, you might get a different answer on the same facts because of the purpose of that particular provision.
Because in those circumstances, one could reasonably view it as the parties have agreed that the check-off provision applies in the context that it will apply to the third party.
So the contract between the employer and the employee in 1988 had check-off in it, and she was employed as a passport officer. Suddenly, in 2001, she was promoted to permanent Secretary of State in the Home Department. That's probably a new job and a new contract. But I don't know whether that's entering into a new contract for the purposes of Section 10, because the clauses, the contractual clauses that are relevant are the check-off. And maybe that when they talk about a contract there, they're not actually looking at the other incidences of the employment contract. They're looking at the contractual term rather than the contract. I just don't know, but there's none of this seems to have been discussed or argued about.
No. So what if I'm allowed to withdraw my concession, and obviously overnight I will consider whether those are my instructions. I submit the better way to view the statute is that where your term and condition included check-off pre-May 2000, then whatever happens to you thereafter, unless you move departments, you are it's not a 1999 Act contract.
Well, I think I've just been skim reading. Subject to the overall question about whether the context was so different, this doesn't give any guidance. I mean, Mrs. Justice Slade does, over many paragraphs, review the whole of the case law on when a contract generally becomes a new contract as a result of changes, going right back to some statute of frauds case from the House of Lords in 1918, but more particularly looking at the employment law cases, because it rises in unfair dismissal, like Hogg and Dover College, where you can dismiss someone, and yet they go on working under and all that. So there's quite a lot to digest here. It may not in the end prove that helpful. We've got to know it's there.
So, my Lord, paragraph 69, which is what you may have looked at, is what I noted over the lunch German, which deals with those, the Hogg and the Marriott Alcan cases, where people essentially said, this is such a new contract, I must be treated as having been terminated from my old contract. And what it said,
so I find that a very unhelpful test as well, because one person said, well, of course it's the same contract, I'm still employed by the Home Office, but I've just got different terms.
so the test that is set out here, which may not be helpful at the end of the day in terms of giving guidance, but it does have some legal merit to it, is the issue was resolved by determining whether the changes were so fundamental that no one could claim that the original contract was still in being. And that may well be the appropriate test.
I think that begs as many questions as it answers, but it may be what we have to end up with, because there may be no bright lines here, which would be a shame. But
my Lord, on the facts of the two cases that we're looking at here, we say that they ought not to have been found to be entering into new contracts. One, because there wasn't a permanent promotion, there was a temporary promotion.
Yeah.
Two, changes to the way in which your hours are going to be arranged is not in itself a fundamental change. And minor changes in pay, again, is not a fundamental variation. It's not a fundamental change.
The impression I got from Mr. Davey, and I may be wrong, is that he worked 7 days a week at London Waterloo, and I can understand why that would be the case, because the trains come in 7 days a week. But when he went to Croydon, he didn't do weekend working, and consequently, there was a change in his hours of work and entitlement to holidays, it seems, because of that. And I don't know how one categorises that. And on top of that, he asked for the change because they did a tour of people who wanted to leave Waterloo and go to Croydon. So I just don't know. I mean, and the facts were rather glossed over, I'm afraid, in the judgment.
Yes. Well, our submission is that the conclusion that was reached on those facts was wrong.
Yeah, but we need to know what the facts are before we can decide whether the conclusion on those facts.
Because even those propositions, as you've articulated them, my Lord, do not amount to a fundamental variation such that all parties would say this is a new contract. So, my lord, I will take instructions overnight as to what, if any, concession I need to withdraw.
Now, I'm afraid that's all come out rather chaotically, and you can blame us rather than us blaming you for that. Have you had an opportunity? Do you want to make further submissions on that point, or is you?
I think I've made the submissions.
Yes, and they're in your
The
skeleton.
question would simply be: do I wish to adopt at least the analysis that Lord Justice Lewis was putting in terms of anyone who was in post on May the 10th,
My lords, yes.
or and do I withdraw the concession on promotion where that contradicts that? And then what do I do with Lord Justice Stuart-Smith's point around?
Yeah, I mean, there are, I suppose, if you'll think about all this carefully, there's a question about a change of position you will have to ask for our permission to make.
Yes.
To withdraw a concession, effectively. It may well be technically that actually doesn't require an amendment because your ground is pleaded in very general terms.
Yes.
There may also be points which come out of this discussion which don't involve you going behind any concession, but are still not where you've put the case before.
Yes.
That sometimes happens in this court, and we're more relaxed about that, but we always have to keep an eye on the other party not being prejudiced.
Yes.
Now, well, that probably would be a good time to break. I suspect Mr. Siegel will be able to be a lot shorter because the person replying always is, but I suspect I'm over-optimistic and thinking we'll finish lunchtime, and I think we should still try. Again, Mr. Siegel, you may say, well, it depends how many questions I'm asked.
It will depend in part on that. I have to say that even were you to be sepulchral, it would be ambitious to assuming that my learned friend's going to spend 15 minutes, say, tomorrow morning. It would be
quite
ambitious to finish.
No, well, I think the answer is, although we hadn't planned on it, we have the afternoon if we want to, but if we need it.
I mean, my lords can always shorten things by saying you don't need to hear from me on certain
Well, there may be
points.
some points on which we don't need to hear from you on, but I doubt if that will be the totality of the case.
No. Well, one can live in hope.
Good, well, thank you very much.
I always think there's nothing more annoying, and it has happened to me.